to you all, and a warm welcome to the penultimate webinar in the EU Transition webinars that we, Hertfordshire Chamber of Commerce, have been running in conjunction with and partnership with the Hertfordshire Growth Hub. My name is John Woodruff. I'm the Business Support Manager at Hertfordshire Chamber of Commerce. I'll pass over to my colleague Lisa Armstrong from the Hub in a second to say a few words, but just a couple of housekeeping points. This is being recorded, today's session on GDPR, data and intellectual property, and questions and answers, questions please, if you can put into the Q&A box. Chat fine, we can look at those as well, but please, all questions into Q&A, which I'm sure you have a lot, and we'll have time hopefully at the end to get through them all. Without further ado from me, I'll pass over to Lisa Armstrong to say a few words, and she is the Business and Strategic Development Manager from Hertfordshire Growth Hub. Lisa, over to you.
Thanks very much, John. Good morning, everybody. I'm just going to share my screen. I just have a short presentation. Bear with me, I'll just get that set up. And if I just, hopefully you can see that okay.
Yep.
Yeah, fantastic. So as John said, this is the third in a series of 4 webinars that we're running with Hertfordshire Chamber. So apologies if you've attended the other 2, you'll have heard my introduction at each of those. But just a very brief introduction to let you know a little bit about Hertfordshire Growth Hub for those of you who aren't familiar, and for those of you that are, just an update on some of our services. So the Growth Hub is led and delivered on behalf of the Hertfordshire Local Enterprise Partnership. We are delivered through a consortium led by Exemplis with the University of Hertfordshire and Hertfordshire Chamber of Commerce. And importantly, our service is free and available to all businesses in Hertfordshire. We are that central point of access for business support in the county, so we work with a wide variety of partners and suppliers, publicly funded organisations and private sector organisations, to bring a host of support to businesses. So anything from wellbeing and resilience guidance, manufacturing support, advice on funding options, and much, much more. One of our core programmes is our ERDF funded programme. So the eagle-eyed among you will notice that European Union logo on the bottom of this slide. This programme is funded through European funding, and it's really around helping businesses to grow and scale. So businesses with 5 or more employees can access this support through the Growth Hub, and through that programme you'd be matched with a growth account manager who would provide support in terms of understanding your business needs, carrying out a review to really understand and develop an action plan for the growth of your business, and importantly to provide ongoing support as well. So obviously we're here today to talk around EU transition. We do have an EU transition readiness support programme, of which this workshop is a key part. And my colleague Brian Stammers will be speaking shortly at the end of the event, just to outline what his team can help you with. But we do have 5 EU transition advisors that are working with businesses currently, really to help them get up to date with transition news and updates as they come available. Also to work very closely with businesses to understand what transition means for your business in particular, and also to help you access a host of fully funded support available at the Growth Hub. Of course, as well as transition, we know that businesses have really had a lot to deal with, and we've been helping businesses through our response to COVID-19 programmes. These include the Volunteer Business Support Scheme from the University of Hertfordshire, and this provides a network of volunteer mentors who are offering fully funded mentoring to businesses that have been impacted by COVID-19 to help those businesses to adapt and pivot. We also have a COVID-19 resource page and hub, which contains all the latest information. In particular, yesterday, obviously a lot of announcements in terms of when things will start to reopen in the country, and there's a lot of information around what that means to businesses as well. We also have a host of on-demand videos on our website, ranging from topics like EU transition, cash flow, trading safely during COVID-19, so do have a look at our website. And also just wanted to quickly mention our wellbeing and resilience programme, because a lot of you, I'm sure as business owners and employers will be concerned about your workforce, may also be looking after your own mental health and wellbeing. And this programme that we've developed in partnership with Hertfordshire County Council really aims to bring you a host of support around a manual and toolkit, an events programme, and working with partners to bring you all the support that you need at a time like this. So if you're interested in a lot of those areas that we've talked about today, do have a look on the website. You can register for free. It just takes a couple of minutes, and you'll quickly be able to access our knowledge bank and our supplier marketplace, visit our events page, and look at our news and blogs. Thank you, and I'll hand you back to John. Thanks very much.
Thank you very much indeed, Lisa. Okay, I see quite a few more people have joined us now, which is really good. What I'll say at this stage is thank you again for joining us. This is the EU Transitionn GDPR Data and Intellectual Property webinar. I'm very, very pleased to say that today we are joined by Longmore Solicitors, who will be giving a presentation very shortly. We'll then follow that by a Q&A session, which will be joined by a couple of other people I'll also introduce shortly. And as Lisa said, we'll just finish off by a summary from Dr. Brian Stammers from the Hertfordshire Growth Hub. So before we go into that, just very briefly, a little bit of work for you. We're just going to ask you 3 questions on a poll, please, just so that we in Hertfordshire, in the Growth Hub and the Chamber, etc., can just gauge where we currently are. Georgia, please, if you could put up the first question. If everyone could click the answer, and that is currently, what is the biggest concern for you as a company relating to the EU transition? It's multiple choice, so please do let us know. I'll just click the button if I can. Oh, we can't vote. Okay, I'm just going to push a button. Okay, get the result in a minute. So 2 winners, digital and data regulations, which is great, and regulation and compliance. So it's just as well. We've got Longmore's today. VAT still very high up there, 14%. We're getting a lot of queries for that, as I know the Growth Hub are as well. And distribution to the supply chain, almost a quarter. That's really interesting. Thank you. And then Georgia, question number 2, please. How prepared do you feel your business currently is regarding EU transition on 1st of January, etc.? Be very interested to see the result on this one, because in the past it's over 50% have been not very prepared, but to just see how we are now. Need some guidance. Okay, still over 50%, which is dead right. Very prepared, 7%. Great. Okay, and prepared 37%. So that's good. That's a good figure. Not prepared, 3%. Well, we are here to help, which I'll come on to in a second. Thank you for that. And final question, please, Georgia. And this is, would you like further support from the Hertfordshire Growth Hub EU Transition team? Very straightforward, of course, yes or no. The results will go through to the Hertfordshire Growth Hub team, and they will be in contact with you to see how they can assist going forward. So once that's gone, we'll then move on to the presentations. Lovely. Thank you very much indeed. Well, so I'm delighted and a real pleasure to welcome our friends and colleagues from Longmore Solicitors. We have Rena Sond. I'm sorry, my eyes aren't too good today. So Rena Sond is a company commercial partner heading the commercial and IP team at Longmore Solicitors. She has over 18 years experience in dealing with a variety of commercial contracts, IP and brand protection issues. She's also a specialist experienced in protecting, managing and exploiting companies' IP assets to their full commercial advantage through licensing, university spin-outs and other arrangements. She's also acted through a wide range of clients such as pharmaceutical, retail, manufacturing, IT and service industries. And Rena is an allied member of the Chartered Institute of Trademark Attorneys and a recognised lawyer in the Legal 500 directory. We're also joined today by Thomas Knight, solicitor company commercial, who has a very strong background in commercial contracts, now working on a wide range of matters with all types of commercial clients, from owner-managed businesses, startups and SMEs to large national and international corporations. Thomas offers a unique insider perspective into how businesses can maximise the value of their contracts to pursue their commercial objectives, and he too is in the Legal 500 directory. Passing over to Longmore without further ado, please, if you've got any questions, put them into the Q&A box. You've got an ideal opportunity to speak to two absolute experts here and more in the panel, which we'll come on to. So without further ado, Rena, over to you, please.
Thank you. Thanks, John. If we can just bring up our slides, please, Alison and Georgia. Thank you. Right, so good morning, everyone. We thought it might be useful with this topic just to really briefly cover and just sort of touch upon the legal framework in the UK, both during and after the transition period. If we could move across to the next slide or two, please. The agenda, as we know, is quite straightforward. We'll be covering and touching on data protection and intellectual property after Brexit, followed by the Q&A session, as John's mentioned. If we can move on to the timeline, next slide. So this is just a useful sort of little timeline which sums it up quite neatly, actually, and essentially just sort of shows over the past year what's been happening. But in a nutshell, the UK left the EU at 11 p.m. on the 31st of January 2020, which is often referred to as Exit Day. In the context of IP, it's referred to as IP Completion Day as well, as of which the UK is no longer an EU member state. The withdrawal agreement came into force on that particular date, avoiding a no-deal scenario. And the agreement was basically designed to minimise the effect of Brexit and was there to aid and bridge the legal regimes that apply both before and after the end of the UK and EU transition period, which lasted most of last year. And basically what that meant was most EU law continued to apply to the UK throughout that period, and the UK was treated for most purposes as if it was still an EU member state. And in relation to GDPR, what that meant is that the main aim of that transition period was to allow transfers of personal data to continue to flow between the EU and the UK. And in relation to IP, the main aim of that period was to prevent the loss of any IP rights that would otherwise flow from the UK's departure. So under the provisions of the European Union Withdrawal Act, retained EU law was created on the final day of that transition period, so the 31st of December last year, and many of the amendments to retained EU law immediately came into effect as of that date. I mean, I don't intend to dwell on it. I think it's been very much largely publicised throughout the press, and everyone's probably sick to the back teeth of hearing about the whole sort of arrangements as to kind of the different sort of legalities of getting this whole process into place. But you know, this is just still quite a useful sort of visual reminder of the whole process that's happened and the amount of time and effort that's gone into getting the various legal regulations sorted out and into effect for the UK. So now I'll pass over to Tom, who will cover the GDPR aspects, and if we can have the next slide, please.
Great, thanks, Rena. So good morning, everyone. Yes, the subheading for this element of the talk is implications for those receiving personal data from the EEA. And this is very much the focus of what I'm going to talk about. But in order to get there, I just need to put the changes into context. So if we just move on to the next slide. So from a legislative perspective, as with other parts of the law, as Rena was saying, the UK has retained existing laws that were put into place during the UK's membership of the EU. Now, for practical purposes, therefore, the data protection laws that apply after 1st of January this year are very similar to those that were in place before it. And this slide just sets out the legal framework of data protection law in the UK, which is made up of 3 elements. So you've got the UK GDPR, which consists of the EU's drafted GDPR as amended by the UK's applied version. Secondly, you've got the Data Protection Act 2018, which sets out the regulatory framework of enforcing the UK GDPR. And then finally, you've got the privacy regulations, which are based on the EU's e-privacy directive, and that governs things like direct marketing by electronic means. So whilst the legal framework has already been put into place before the 1st of January 2021, after that date, the UK can make whatever changes it likes to the data protection laws. Also, any decisions that have been made by the EU courts on how EU GDPR should be implemented can be overridden by the UK courts. And future changes to EU GDPR, therefore, will not be reflected in UK law, and neither will decisions of the UK courts. So that's just a brief background. If we just move on to the next slide, please. Thanks. So how can data transfers of personal data from the EU to the UK be legal after the 1st of January 2021? Well, under EU GDPR, a transfer cannot be made to a non-EU country, which is what's called a third country in the EU's eyes, unless one or more of 3 criteria apply. So firstly, the transfer could be made to a country which the European Union has deemed as having an adequate level of protection for data transfers. Now, the process for being approved as having adequate protection is very lengthy, and the Commission has to look at the relevant country's laws and protections for individuals. But once an adequacy decision has been made, data can flow freely between the EU and that third country. And not many nations have achieved this yet, and the UK is still waiting to be formally found to have adequate protection. So secondly, you could, in the absence of an adequacy decision, transfers can be authorised if there are appropriate safeguards in place to protect the personal data. And I'm going to come on to some relevant safeguards on the next slide. Thirdly, alternatively, there are what are known as derogations, which are effectively exceptions to the general prohibition on transfers. But these are very much a last resort. And again, I'm going to talk more about specific derogations later on. Now, because the UK has a virtually identical data protection regime to the EU, these restrictions apply vice versa for data transfers from the UK. The UK has already said that it recognises the EU and EEA members as having adequate protection. So a lot depends on whether the EU will make a decision on UK adequacy, because this will mean that businesses do not necessarily have to rely on using other appropriate safeguards or one of the derogations. Now, only last week, the European Commission published a draft decision that said the UK did have appropriate protections, and this is very good news, but it's still just a draft decision, and formal confirmation of adequacy might not happen anytime soon. So if we just move on to the next slide, please. That's great. So with that background, and in the absence of the UK being recognised as having adequate protections, what steps can you take to ensure businesses can still receive data from the EEA? Well, the first thing to point out is that as part of the Trade and Cooperation Agreement, a temporary bridging mechanism was put into place for data transfers from the 1st of January. So for 4 months, the UK will not be treated as a third country for the purpose of transfers from the EEA. And there's an option to extend this for 2 months if neither side objects. So this means that in the short term, the free flow of personal data can continue uninterrupted as during the transition period. So as I said, it's helpful for the short term, but whilst the EU has made a draft decision on adequacy, there's no guarantee of formal confirmation of this before the bridging mechanism has expired. And in the absence of an adequacy decision, the Information Commissioner's Office, which upholds information rights in the UK, has recommended that businesses put appropriate safeguards in place by the end of April. So if your business relies on having data transfers, from the EEA, it's important to start thinking about this now. I mentioned on the previous slide that in the absence of an adequacy decision, businesses can use appropriate safeguards that provide an effective legal remedy for data subjects. Now, the most relevant of these for most people attending this presentation will be either the binding corporate rules or standard contractual clauses. Now, where a data transfer is carried out by an EU established company to other members of its group in a different jurisdiction, transfer can comply with EU GDPR if it's governed by a set of legally enforceable binding corporate rules, or BCRs, which apply to all group companies. And they must have been approved by an authority in the EU. Now, the BCRs will ensure that data subjects' rights are preserved. However, it is quite difficult to obtain approval for these rules, and that means that most businesses, it might not be proportionate to try and agree them, and only large multinationals, I think, have seriously given this consideration so far. So a realistic alternative for most businesses is to use the standard contractual clauses, which have been drafted by the European Data Protection Board. Now, the SCCs, as they're referred to, are bilateral contracts between data exporter in the EU and data importer outside the EU. And the clauses, they can't be amended because that would just undermine their effect. So for practical purposes, these are possibly the best option, but do note there has been a recent decision which is called the Schrems II case, made by the European Court of Justice, which largely concerned the validity of the US's Data Shield program, but it also gave important guidance on the continued use of SCCs. Now, the ECJ said that SCCs are still very much valid and very important mechanism, but they shouldn't just be put in place and forgotten about. And the ECJ said that data exporters from the EEA must conduct a risk assessment to see whether these clauses actually work in practice. And if they don't, then it's worth thinking about other protections that can be put in place. Now, for the purposes of transfers to the UK, it's unlikely a data export would be considered to fall foul of such a risk assessment because, as I've said, there's a virtually identical regime here. But the point is that data exporters from the EU will need to show that they've made this assessment. So just using standard contractual clauses should not just be relied on without having thought about where the transfer is going and what personal data is being sent. So I've spoken about what businesses can do in terms of appropriate safeguards to ensure data can be transferred, but there are some derogations which can be relied on. Now, the most appropriate derogations that businesses may look to rely on are those that the data subject is given explicit consent, or that the data transfer is necessary for the performance of the contract. Now, in terms of the consent derogation, the data subject must freely consent to the data transfer, so it can't be forced into doing so. And the problem with relying on consent as a mechanism for making a transfer is that it can be withdrawn by the data subject. So the controller making the transfer cannot ensure they have a long-term reliable basis on which to make that transfer. Now, it is possible to rely on the fact that transfer is essential for performance of the contract, either between data subject and controller or controller and third party. But a drawback of this is that the transfer of data cannot just be due to an individual organization's structure. So if your business just outsources its operations to the UK, that derogation might not apply. So that's just a really quick summary of data transfers from the EEA to the UK. I mean, we're all hoping on that decision of adequacy is forthcoming. But in the absence of that, you should plan for the possibility that the UK won't be found to be adequate, and consider what lawful basis you can make transfers from the EEA if you are reliant on doing so. So that's the data protection aspects. I'll just pass over to Rena now.
Thanks, Tom. Next slide, please. And again. Great. So the UK and EU Trade and Cooperation Agreement was agreed within the last year, and that basically sets out minimum standards on IP protection and enforcement to which the UK and EU will remain committed. And in broad terms, what each party's agreed is that they'll treat the nationals of the other party in a way which is no less favourable than the way in which it treats its own nationals with regard to IP protection. So first of all, then, what I'll do is cover the main forms of IP rights and protection that is available in the UK and the EU. There are ancillary rights and sort of more specific and specialised rights, such as plant variety rights, database rights and things like that, which we won't delve into today. I will focus just on the main forms of IP that will be of most relevance to businesses and attendees today. So starting off with trademarks, there was essentially a need to ensure that business owners which relied on EU trademarks for protection in the UK didn't wake up on the 1st of January this year with absolutely no UK rights. And so to ensure the continuity of that protection, on the 1st of January, the UK IP Office automatically created around 3 million UK trademarks and design rights for holders of EU trademarks and community design rights, and also international trademarks that include the EU. And so those UK comparable rights that have been granted have been registered free of charge and sort of almost duplicated into the UK. And obviously with 3 million, for logistical reasons, the IP Office didn't issue registration certificates for those marks. But essentially, these new comparable trademarks are UK rights that are entirely independent from EU equivalents and will be treated as if they had been applied for under UK trademark law. And this means that they will have the same status and effect as UK trademarks and have the same filing date as the original EU rights. And the filing date is obviously quite key when you're looking at protection, because it's often a case of who gets there first. So on a practical note, it's certainly worth reviewing the details of any new comparable UK rights that you may have that have automatically been granted in relation to both trademarks and design rights. In terms of renewals, so the comparable marks will have the same renewal date as the corresponding EU trademark. And so although they're independent, they'll need to be renewed separately, and it's important to therefore check the renewal dates of both the comparable mark and the EU marks quite closely, because there is a risk that important trademark rights could inadvertently be allowed to lapse through non-renewal. So it's worth sort of just keeping track of that. For those trademarks and designs which were pending as of the 31st of December last year, those particular marks that were sort of ongoing and hadn't been completely registered will not have automatically been created to receive a comparable UK right. So people that had applications that were still pending as of the end of last year will have to now separately file a UK trademark or design right in the UK. And they've basically got until the end of September, 30th of September, to do that. And any application for a corresponding trademark or design has to be for the same application that was originally being provided for last year, and filing fees have to separately apply and be payable for those UK applications as well. And importantly, it has to contain a correspondence address in the UK now. It cannot be somebody that's focused and solely based in the EU. The same thing applies in terms of the preservation of rights in relation to any pending disputes. So any ongoing disputes with trademarks or designs in terms of oppositions or cancellations that took place before the EU IP Office as of the 1st of January, and those which rely exclusively on a UK trademark will actually fall away. So you lose the right unless you have, before the 1st of January, registered an EU address for service or an EU representative to deal with that, with those proceedings on your behalf. So UK trademarks can't be relied on exclusively for EU trademark proceedings, although you can still show evidence of the proof of use in the UK before the 1st of January, and that will continue to be relevant, which is helpful. Further, it will no longer be possible to file an opposition or a cancellation action against an EU trademark relying solely on an earlier EU trademark right. And the same thing applies the other way, though, that the EU trademark owner can't be relied upon with their trademark to oppose or challenge a UK trademark either. So it does level the playing field, thankfully. And then finally, if there's any EU trademark which is declared invalid or revoked, then the corresponding comparable UK mark will also be cancelled. So the same rights will apply in the UK as they do in the EU. As I mentioned, in terms of design rights, similar changes have happened as with the trademarks, as I've just mentioned. So automatically granted re-registered designs and continuing unregistered communities of designs have again been duplicated into the UK, so corresponding UK rights now also exist. And again, it gives the holders of any international registered community designs an equivalent UK right as well. And then finally, there's also laws which have created a new UK unregistered design right, which mirrors the characteristics of the unregistered community design. And this is called a supplementary unregistered design. And it's got the same scope as duration as an unregistered community design. And so, as well as granting each owner a new UK design matching the rights that they've lost, the law is also basically intending to again preserve the rights which are associated with pending applications, and again with any sort of ongoing cancellations and so on, the same effect takes place. And again, in terms of invalidity proceedings, UK rights will cease to be seen as earlier rights in relation to the EU IPO procedures. And also legal practitioners based in the UK or qualified only in the UK will no longer be able to represent parties before the EU IP office, except where proceedings are ongoing. Just turning to the next slide, I have outlined on this slide just some practical pointers, some of which I've already just touched upon, but also a few points which relate to IP assignments or licenses that might be in place between commercial parties. And there's a few things on this slide just to note on a practical level that might be worth checking to ensure that the protection is still sort of there in relation to any new UK comparable trademarks or design rights that have materialised since the 1st of January. Moving on to the next slide and next topic of copyright. So copyright is probably the most commonly owned type of IP right, and copyright law has largely been harmonised across the EU already. And in addition, the UK is a signatory to a number of international copyright treaties as well. So this means that most copyright law will remain, at least for the time being, largely unaffected by Brexit. Although it may indirectly be affected if the UK diverges from the EU in future. There are, however, a few specific areas of copyright which have been affected, and I've listed those on the slide. So it's things around sort of satellite and cable broadcasting rights, orphan works where the owner of copyright is unknown or can't be found, and so on. But again, I don't propose to cover those changes today, but if there is any queries on that, then I'd be happy to deal with those separately. Mentioning copyright law, there will actually in the near future be some divergence between the EU framework and the UK, because the Digital Copyright Directive is basically due to be implemented in the EU member states by the 7th of June, and the UK is no longer implementing that. So already you'll see that this year there will be some divergence in terms of copyright law, which was previously quite harmonised. The directive, though, is still relevant, just so that people are aware, and businesses that do have a presence in the EEA, and particularly those that are sort of consist of online platforms, will still need to be aware of what rules are in other member states in future if they've got a presence in those states, particularly around notifying online content sharing service providers about infringing works, and so on. Moving on to the patents on the next slide. So you'll be pleased to hear that, again, Brexit hasn't really had any direct impact on the application process or registration system for UK patents, which are administered by the UK IPO, or European patents which designate or include the UK. And the UK's membership of Patent Cooperation Treaty remains unaffected as well, and European patents will continue to be enforceable in the UK in the same way as before exit day, and proceedings that may have started before the 1st of January also are able to continue undisrupted. Many of you might be aware of the unitary patent, and basically this is a sort of a combined European patent, which has been sort of in planning, and it's basically to make, it's been in progress just to make patents less expensive to get and more readily enforceable throughout the EU, and it basically is to enhance the single market in Europe and to make them more competitive in terms of patent protection with particularly countries like US and China. And the patent is a single uniform patent right which covers all member states of the EU, but obviously that will now exclude the UK. It's relevant to all of the EU member states who have signed up to an agreement to establish this patent system and submit to a Unified Patent Court, or UPC, which is also an essential part of this new coordinated process, so that it can deal with settlement of disputes relating to European-wide patents. All EU member states have signed up, as I say, except for Spain and Croatia, and now also that will include the UK, who are excluded. And they'll only be available once the court itself has been established, and it's currently unclear when this will be, and actually the future of the whole system itself is actually open to doubt. So it's looking very unclear as to whether this whole sort of UP and UPC system will actually go ahead at all. But it's become very clear that the UK will now not participate in this system as and when it gets off the ground. Next slide, please. And then lastly, on to EU domain names. So this is sometimes, domain names are sometimes grouped together with IP rights. And whilst it's not a strict IP right, I thought it might be worth mentioning because this may well be relevant to a lot of businesses who have an EU website or a .eu domain name ending as part of their website. So going forward, whilst people might be familiar with Nominet, who are the UK registering body for sort of the .co.uk and .org.uk domain name endings, with those registrations, those domains are welcomed to be registered from anyone, anywhere in the world without any restrictions in terms of territory, and that won't change. In contrast, with domain names that end in .eu, these are managed by a body called EurID, and those domain names may now, going forward, only be registered by an individual who is a citizen of or a resident in an EU member state. Obviously, now that excludes the UK, or by a business or undertaking who is established in the EU or the EEA. And there will be a notice being sent out to UK registrants on the 1st of April this year, stating that their EU domain name is withdrawn as of that date. And all withdrawn domain names formally allocated to UK registrants will be revoked and be made freely available for general registration only for those businesses that meet this criteria on this slide. From January next year. So there will be some big changes coming with these .eu websites, particularly from next year. So just in conclusion, as we've seen, whilst Brexit has no direct impact on IP rights which are registered already in the UK, it has resulted in significant changes to EU trademarks and community registered and unregistered design rights, where those equivalent rights have been granted into the UK. And this will indirectly affect UK trademarks and designs. So we'll have to wait and see how that works. Thankfully, Brexit has had very little impact on patents, copyright and trademarks and confidential information. And looking forward, it seems the UK will inevitably diverge from EU law as time goes on. And hopefully that will create further opportunities beyond the EU. So time will tell. But that's the end of the presentation. If you could move on to the next slide. And I think we're now on to questions and answers. Thank you.
Rena and Tom, brilliant. Thank you so much. There are Rena and Tom's our details that are up there, so please do contact them. I think I'm okay in saying that. Should you have any queries. Time is moving on. We've got a few questions which I'm really pleased about. So if we go straight away into the panel, which Rena and Tom will be around for, which is great. We're also being joined joining in the panel with Sophie Chase Borthwick, who is VP of Data Ethics and Privacy at Caligo. She's been there since 2018, and Sophie is responsible for leading the privacy practice globally, supporting clients in their ongoing data privacy observance, whatever their jurisdiction. And also Dr. Brian Stammers, as I mentioned earlier, is a lead EU transition advisor at Hearts Growth Hub. And Brian, I believe you have quite a background in IP as well. So I think without further ado, so we've got about a quarter left, so we get as many questions in as possible. Paul Finch has asked, I think, Paul, can I bring you into our sets? I think it's two questions. You might have a bit more leading for that. Georgia, could you unmute Paul, please, if he's still there, to ask your questions about data? And this was directed towards Thomas, I think, largely. So, Paul, over to you.
Good morning. Can you hear me okay?
Yes, we can.
Very weird. I can't see myself, but I guess you can see me. I don't know.
We can see your picture. There you go.
Thank you for the chat. I was reading in the Times on Saturday that I thought that the EU had approved our data adequacy for GDPR purposes. So you're suggesting that's not quite the case, is that? That's question number one. Question number two, I run a web-based data collection system. I'm in the world of collecting information about stress in the workplace. So I have clients all over Europe whose employees are completing questionnaires on our systems. So, and at the moment, of course, we've been able to guarantee data adequacy and GDPR by confirming that our data centers are all held in the UK and within the EU. So it's a very complex area, I know, but I just really wanted to firmly understand how sweeping is, what counts as data transfer, I think is one of my key things. And is it sweeping up emails and things like that? You know, so just, you know, as simple as you can make it, Thomas.
Yeah, understood. Okay. Well, answering your first question, yes, I mean, the decision that came out last week, as I understand it, was just a draft decision. So it doesn't actually give formal confirmation of adequacy yet. So, I mean, it's a step in the right direction, certainly, and it's very reassuring for businesses, but we're not quite there in terms of having the same protections we did when we were members of the EU for data transfers. I mean, I think, you know, the UK recognised that the EU was adequate, but there wasn't a reciprocal arrangement, potentially as some sort of bargaining chip. But hopefully it's not far away. But it can take time, which is why I said that it's important to think about other means of protecting data, but also the kind of ethos of data protection overall is to make sure that you're not just relying on, say, adequacy. You are actually thinking about these data transfers and what you as a business can be doing to protect personal data. And that leads on to your second point: what is a personal data? What is transferring personal data? I mean, there's a very broad definition of personal data in UK and EU GDPR, and it's basically anything that can be used to identify an individual. So, you know, names, addresses, email addresses potentially. So if you are moving that information from a European base to a UK base, you need to be thinking about, you know, what is the lawful basis on which we're doing this. Does that help?
Yeah, I suppose my question is if the systems are running on our servers in the UK, technically there's no data transfer rather than what's physically being entered on their screens, if you see what I mean. So there's no physical, I mean, there's a technical one. So is the fact that they're entering information on a screen in a EU state coming back to our servers, that is deemed data transfer, is it? That's what I'm trying to understand.
Yeah, I'm not an IT expert, but I think that would probably come within
Right.
the definition of
I
transfer.
was going to say, if I may, yes,
Yeah.
it is.
Right.
Probably the easiest way to think of it, instead of hanging up on the word transfer, is think of the word access.
Right.
Because the way that the modern world works technologically, we think of transfer as in literally moving things from here to here, like an old-fashioned letter. But in practical terms, if you think access, it's probably easier.
Okay. All right. Thank you. All right. Thank you.
Mute, John.
John, sorry, we can't hear you.
Sorry, yeah, it's because I've got drilling going on with the builders, so I keep cutting off. Sorry. Thank you, Sophia, for coming in. I was going to ask you to come in, and thankfully you did. Shona Davis. Shona, do you want to be unmuted by Georgia and just ask your query, and then we go to the Q&A ones, please? It's quite a complex question you've got there, I think.
Hi. Thanks for putting this together. Very, very useful. I work with a lot of global organizations based in the US, Europe, all over the place. One of the things that's become a bit of a topic of interest for quite a lot is bringing, and it relates to what you mentioned, Rena, about cross-border transfer of online content, working in sort of web online services. This is, you know, trying to put together principles around use of images, use of online content, scraping data from one place to another. The rules are murky enough to begin with, and I'm not sure I understand what now has changed from where we used to be able to say, credit somebody. Is there more that we now need to do in order to use images, content that's online from a member state, from an EU source?
So the rules around copyright, certainly in the UK, the position hasn't changed or been affected by Brexit. But as I say, there are some changes coming, particularly with the with the Digital Copyright Directive. And as I mentioned, the UK has decided that they won't be implementing that. So certainly the UK sort of position on, you know, the English law position will remain very much the same as it has done. However, as I mentioned, if you've got a business where you're dealing with EEA member states, then those, you know, you need to make sure that if you're dealing with those territories that you are aware of what the rules are. Now, because the directive still is in draft form and hasn't come in, and it won't until sort of June time, I don't know the precise details of what those requirements may be in relation to copyright content and sort of scraping images that you mentioned. But where you do provide online content, then the changes, as far as I can see, relate to sort of more online content sharing providers. So sort of more sort of where that sort of thing is part and parcel of the service that you provide. So it's sort of more like service providers, online ISPs, internet service providers is how I've certainly interpreted it. So I think it's a case of waiting and seeing whether there will be any further guidance released on what the requirements might be in relation to that. But in terms of copyright of that content, as I say, I would continue to go by what the current position is, certainly within the UK. but it's certainly worth keeping an eye out as and when that directive does come into force to decide whether, you know, and see whether that will actually place further obligations on UK businesses where they are using and transferring data to those countries.
Okay, thank you.
Thank you very much indeed, Shona and Rena for the answer. Next question, are UK patents no longer recognised in the EU? We received dozens of requests to translate patents into French over the last 6 months. Who wants to take that one?
Yeah, I can. Patents and, in fact, most registrable IP rights are by their very nature territorial. So generally you would need to apply for any IP rights that you want, including patents, in the actual territories in which you want that protection. And quite often that will be determined by the markets in which you want to operate or sell, or you know, where your major sort of marketing and the sales sort of activity is. So the EU-wide patent, there isn't one that is a sort of a unified system as yet. It's this unified and unitary patent system I was talking about that's all still sort of in progress. So if you want patent protection in the EU, you would need to apply for separate protection and have patent applications actually made in the specific countries in which you want that protection. A UK patent in and of itself wouldn't give you protection in the rest of the EU. It would only give you protection in the UK. You need to register the patent in every territory in which you want that protection to last, because that exclusivity over what you've developed will only apply in the country in which you register the patent.
May I make an observation here, actually, from practical experience and pick up what Rena was saying? In practice, what a company needs to do is establish a patent plan, to work that out with their patent attorney, who is the person that will advise them and administer it for them. The process takes some time, because obviously sometimes you have language issues to consider. You also have local legal issues to consider in terms of local patent law. But the bottom line is, if you're going to go out on the world web, what you need to do is you need to have a proper plan. You need to know where your key markets are. Don't get into a situation where you have patents everywhere, knowing that in many cases it's not going to be a commercial viability. So choose your territories carefully and make sure that you understand that, as with all things, the cost of patent protection will increase as you roll it out. So not only do you need to know that the countries that you want to focus on, you also need to know what your budget is going to be, because it will roll up.
Thank you, Brian. Karina, you've got several questions there. Do you want to come in, Georgia, if you could unmute Karina to ask direct, please?
Hi, how are you? Good morning or good afternoon now. Thank you very much for the talk. I think this topic has been very, very interesting indeed. My question is, I think it's been slightly answered by when Rena answered the question about patents. Is regarding the design of company logos, if the trademark and design rights also apply to company logos, and if by registering the design, for example, in the UK, if it's guaranteed that it won't be copied anywhere else in the world, but then I think your may apply the same principle as patents, doesn't it?
Yes, that's right, Karina. As I said, with the patents, the same principle does apply to both trademarks and designs as well. And if you wanted to protect your company logo beyond the UK, you know, as Brian has alluded to, it's important to look at and assess and work out where your key markets are, and apply for protection potentially in those territories, in those markets, rather than worldwide. Because again, if you're looking to protect it worldwide and globally, you know, there's an argument that it could be open to challenge in future if you're not actually using or trading in that particular country for non-use. So focus on the markets in which you want to sort of really actively market and sell your goods and services, and look to protect your trademark, your company logo through a trademark predominantly in those particular countries. You can still apply for an EU-wide trademark, but obviously that will now exclude the UK, so you would need to separately apply in the UK as well. And there is a sort of a worldwide trademark system as well that can also be used to help, which helps to streamline the whole process of applying to register your trademark in lots of different countries outside of the EU as well as within. And that's a much better streamlined process. So there's systems in place for things like that to help make the process a bit easier. But obviously the more countries you want to protect in, the higher the filing fees in relation to that.
Right. And this is probably a question now for you or Brian. How commercially viable, or is it really worth, because of the cost incurred in this, is it really worth registering the logo for us to be protected?
I think it very much depends on how strong your brand or logo is that you've created, because your company logo might not actually be the same sort of logo and everything as the brand that you've built up around the goods and services that you sell. So it's a case of looking at what's of most importance and what really sort of identifies with consumers in terms of what they look at when they buy goods and services, and whether or not they would look at your particular brand. And if you place a lot of weight and importance on that brand, and it's been built up in terms of reputation and recognition, then you know it becomes more important to make sure that that is protected. If it's still relatively unknown, you may want to protect it before it gets to that level of recognition. Again, it's part and parcel of what you should have as a sort of an IP strategy, to look at what IP and other IP rights you might have in place, because there might be other IP rights that are actually more important, such as a patent. The brand itself may or may not be part and parcel of that global sort of strategy, that broader IP protection strategy. I think for the most part, it's certainly worth doing, certainly in the UK, because it's quite quick and easy and inexpensive compared to a lot of IP protection rights that are registrable. But it very much depends on what your sort of timescale budgets and markets are, I think, to a large degree on that.
Right, thank you. Thank you very much.
May I just pick up from what Rena was saying there? A lot of very high technology companies, and I'm thinking, for example, in the pharmaceutical sector and diagnostics, will tend to focus on patents as being the only answer to intellectual property. I always try to advise them that actually patents are fine, and they're very important, and you must have protection where you need it. However, trademarking is actually the opening of the door for branding. And if you have a product you want to take forward onto a worldwide market, your branding is very important. And in order to support that, you really need a sound strategy for trademarking. So I'm absolutely 100% with Rena on that.
Thank you. Thank you very much.
Thanks, Karina. Okay, we've got 3 questions to go. We're on 12, so I have to rush through a bit more. This is Peter Hayden from NGK Spark Plugs. Are you able to comment on changes, requirements around exhaustions of IP rights in relation to UK companies re-exporting goods into EU and vice versa? Who wants to take that one? Silence. Any takers?
I'm going to leave that with the legal people, I think.
It's a difficult one, and unfortunately we've probably not got enough time to sort of go into detail on this topic, because it's quite a challenging one in and of its own right. But you know, the only thing that's worth mentioning, I suppose, is the fact that if there were any IP rights which were exhausted, prior to the 1st of January this year, then those rights remain exhausted. And so, you know, you've got to make sure that you are clear about exactly what IP rights you've got in terms of what you've, you know, in terms of those goods and services that you're importing or exporting. It's one of those it's a little bit tricky to sort of sum up, I think, in a few words, really, but happy to have a further conversation with Peter after the event if that would be easier. I think that's probably the best approach on that one.
Thank you. Last two. We have a trademark of a business name registered in the UK. Do we need to register that trademark in the EU as well?
Yeah, again, it's the same sort of thing, really, as Brian and I have both mentioned, which is if you want that protection across the EU, and as long as you're actually using that brand or trademark in those EU territories, then it's certainly worth still registering. It depends on whether or not you're actively selling goods and services into those EU countries as to whether or not that protection is actually warranted or not. If you're a small, you know, local business that has a lot of trade and is based on a geographic location, then, you know, EU protection just isn't going to be relevant to you most of the time. So it very much depends on the nature of your business and where you're actually selling your goods and services on as to whether or not you would want to protect in the EU.
Brilliant, thank you.
Just picking up on the last question and just finishing off on that, what I would say is if you're concerned about lapsing of patents or lapsing of trademarks or indeed designs, the best way to make sure that they don't lapse is to work very closely with your IP or trademark attorney. I'm not being an apologist for IP attorneys and trademark attorneys, but you know, they are there to help you protect your intellectual property. And if you don't use them, you do risk losing your IP. So be warned.
Sound and sage advice there. And last question, is it important now, I'm sorry if it's drilling, or will it become important in the future if you hold EU data in the UK to appoint an EU representative who becomes your EU data controller, answerable to the EU regulator? Quite a complex question there in itself, but
so the short version is yes. There's a long version, which is that it's not about just about holding data. It's also about targeting the EU. So even if you hold EU data in the EU, if you're a UK company targeting the EU, this provision still applies. You still need to have an EU representative. Also, technically, they're not a controller. You are still the controller. The EU representative is a processor acting on your instruction. But yes, once this extended transition period ends, be it in April or in June, whether the UK gets adequacy or not, you will need to have a representative in the EU where most of your data subjects are based.
I just keep having to unmute and mute. Thank you, very succinct response there. That's at the end of the questions. We are very, very close to being out of time. Sophie, did you want to say a couple of words at all, or are you about anything, or any summing up, or are you okay?
No, the main thing is that GDPR and don't have to worry about if things are in the UK data center or a EU data center. What you need to make sure is all those protections that Thomas mentioned are in place either way.
Fantastic, thank you. We come to Brian at the end. Tom, Rena, anything to add in the closing seconds, minutes, whatever?
No, just thanks to everyone for coming along.
Indeed, yeah. And thank you very much to you too, which we come to. Brian, did you want to say a few words?
I would say a very few words because I know we're short of time.
Yeah, sorry.
Basically to say that BEIS has funded a program throughout the growth hubs in England to support the EU transition, which they have now reverted back to the word Brexit, which is a word that everybody now understands. We have a team of 5 people who are all experts in international trade. 4 of us have been trade advisors with DIT, Department of International Trade. Our role is to try and help companies understand their way through the myriad pathways that seem to exist in and around Brexit and EU transition. So far, and we really only started this exercise at the beginning of January this year, we have engaged proactively with something in excess of 350 companies in Hertfordshire. A lot of those have responded, so about a third of them have responded to our initial outreach, and something like 25% of them have actually given us an indication as to where they are along this process from I don't know anything about it to completion. Most of them we would have to put into the work in progress area, even though a number of them will say and believe that they are completed. The problem we find is that those companies that think they have completed the process, when we actually talk to them in more detail, it becomes very apparent that there are things that they didn't know really applied to them. This is going to become more and more important as more and more detailed information comes out of BEIS and particularly HMRC with the VAT and duty regulations and rulings. The issues that are causing problems: VAT and duty, shipping, documentation, proof of origin, which is becoming an increasingly big problem, Northern Ireland, which we all know about. God knows how that's going to get resolved, I don't know. And then finally, documentation issues that are holding things up at import points. We hear of situations where people get their products held up at Rotterdam, for example, because the documentation said source of origin UK. No, it's not, it's GB. So there's a lot of work to be done, but I think we're making some good progress, and the businesses in Hertfordshire, I hope they think they're being well supported. We're there for them, and all they need to do is contact us through our website. That's it. Thank you.
Thank you very much indeed, Brian. Just leaves me to say the final EU transition webinar in this series will be on the 11th of March, covering supply chain. I know some of you in the poll at the beginning, 21% of you were querying about the supply chain. That's at 1500. Do please register for that as soon as possible. And just leaves me to say thank you very much indeed to Sophie for your contributions in the panel, to Tom, Rena, Tom, for your great presentations in what is an incredibly complex and ever-changing, as we were saying at the beginning, ever-changing situation, but really, really succinctly put. And thank you so much again for all your help, and also to Brian and Hertfordshire Growth Hub. And likewise, we at Herts Chamber, if you need anything, do contact us. So that's it from me. Have a good rest of day. Thank you again, and take care, everybody.